Hello everyone, welcome to CashcroftTV. My name is Kaylin Ashcroft. Thank you very much for watching this video on Guide to Legal History and Historians, where we will be covering all of the chapters from the Oxford Handbook of Legal History, edited by Marcus D. Dubber and Christopher Tomlins, where today we'll be covering What Do Contracts Histories Tell Us About Capitalism, from Origins and Distribution to the Body and the Nation by Anat Rosenberg, and Historical Analysis in Criminal Law, a Counter-History of Criminal Trial Verdicts by Arlie Loughnan. I've shortened the titles for the purpose of shortness to Contracts and Criminal Law 2. I call them these contracts because this is the first chapter that really covers contracts in specific detail, and Criminal Law 2 because we have previously covered criminal law. However, in no way, shape, or form is this one chronologically secondary or secondary in terms of merit. It just happens to be the second chapter focused on criminal law, however, a very different purpose. And I apologize in advance for the velocity of this. I had a long day and we were working on a trial at work, so we're going to try to finish this before sun sets. But I say that ironically because a lot of people apologize for taking more time and in effect take more time themselves. But nonetheless, I say it once, say it now, and will not say it again. And feel free to slow this down however you can, if you prefer. So, without further ado, we will start with the chapter on contracts and a biography of Anat Rosenberg. Then we'll move to the chapter on criminal law, and then preceding that, a biography on Arlie Loughnan. And then, in the style of Plutarch's Lives, we will have a comparison between Anat Rosenberg and Arlie Loughnan to perhaps learn a little bit more about both of them and their respective works. So, without further ado, we will start with contracts law. So, a brief biography of Anat Rosenberg. She completed her Bachelor of Law, magna cum laude, at the Hebrew University, and she received her PhD in 2011 at the Tel Aviv University in the direct doctoral course. She works at the Harry Radziner Law School at Reichman University, where she is a professor. She's also a fellow of the Royal Historical Society. From 2017 to 2020, she was a visitor at the Faculty of History at the University of Cambridge and the Institute of Advanced Legal Studies, the University of London, as well as Wolfson College and thereafter Emmanuel College at the University of Cambridge as well. She has been a research fellow at the Satcher Institute for Legislative Research and Comparative Law from 2010 to 2011, and a visiting fellow at Columbia University in the United States from 2006 to 2007. Her research uses methodologies of cultural legal history, law and the humanities, and law and literature, and most recently completed a book on cultural legal history of advertising in Britain in the first era of mass consumption, which is circa 1840 to 1914, titled The Rise of Mass Advertising, Law, Enchantment, and the Cultural Boundaries of British Modernity, published by the Oxford University Press in 2022, and Liberalizing Contracts, 19th Century Promises Through Literature, Law, and History, published by Routledge in 2018. Her new research projects include International Research Network on the Enchantment of History of Capitalism, and an edited collection on law and the material term. Her areas of expertise more specifically include the history of consumer capitalism in late modernity, liberal thought in late modernity, liberalism critique, particularly the role of class and gender in liberalism, cultural legal history, the interrelations of law and literature, contract law, consumer credit, advertising law, marriage promises, Victorian fin de siècle novel in England. So many areas of focus, so very fitting that she's included in this very important and valuable monetarily and in terms of intellectual value with the Oxford Handbook of Legal History. So she opens up her chapter with noting that it was written at the Radziner Law School, the Interdisciplinary Center, the IDC, and Herzliya, and she thanks for the helpful comments. The author is grateful to the participants of the private law workshop of the IDC, UPF, and McGill in 2017. And at the Berg Legal History Workshop, TAU, in 2017. The author thanks Ron Harris, who we have a chapter on, which I encourage and hope you watch, or have watched, and in which case I'd be thankful. Moran Offer, she also thanks, and Ronit Levine-Schnur for their thoughtful discussions about this chapter, as well as Noah Nitzen for her excellent research assistance. So, starting with section 1 of her chapter, titled Contracts Histories as Histories of the Capitalist Order. So the author notes, contract histories are inextricable from the history of capitalism. Not only functionally is capitalist life dependent on contracts for labor, capital, and consumer goods and services, but conceptually it is as well. By age of capital, as Eric Hobsbawm called the era of the global advance of capitalism towards the mid-19th century, the cultural association of the concept of contract with ideas of markets and economic liberalism superseded an earlier dominance of contract as a principle of political sovereignty handed down by social contract philosophers, which itself overshadowed associations of contract with covenant theology and natural law jurisprudence. So that's interesting for me. I always thought contract law was just based sort of a private law sort of thing, but it sort of has roots in natural law and theology. There are resonances of contract law remain valid. Resonances of contract remain valid, and grasping the field of contract histories and deep significance requires reading it as a set of debates about historical capitalism rather than reviewing histories either chronologically or methodologically. So that is her prescribed way of researching this area. And the chapter reads contract histories as discussions about capitalism. Therefore, what do these histories tell us? What kinds of concerns do they betray? The chapter's case study is Britain, the first capitalist nation, according to the author, in the late 18th and 19th centuries, so sort of taking a specific point of time in a specific region, however, probably the most important region, according to her, and time period, in the era in contract scholarship known as the high point of the classical model of contracts, which remain influential still. Histories of the era viewed as a whole address capitalism within two established modes of political economic debate, which consider the origins of capitalism and its distributive effects. So we're going to cover the origins of capitalism and the distributive effects, so kind of two different perspectives in which to study contracts history. The first part of this chapter describes the two dominating concerns and a way in which existing contracts histories coming from a variety of historical schools significantly coalesced around them, those two areas being the origins and distribution. And the second part of the chapter seeks to move beyond the concerns and offers two other perspectives on contracts and capitalism, namely embodiment and nationalism. So, without further ado, we will start with part 2, where we will be covering origins and distribution. And this section is called Section 2, Dominating Concerns, which are origins and distribution, as we shall see. So the author notes, two organizing questions have long informed the histories of capitalism. Origins, when capitalism emerged, intertwined with determining what elements are fundamental. And distribution, questions of economic, social, and cultural equality in capitalism. Histories in Britain in late 18th and 19th century, particularly according to the author, largely correspond with these two themes. For study, the author has separated them, but they are not mutually exclusive. Such a material and ideation effects of law, disagreements about the role of law in relation to law's internal history, and mixed normative evaluations of legal developments all play roles here. And therefore, this chapter will take a broad view to highlight the thick points of controversy and research, and point to methodological and theoretical richness of existing work. So we're going to focus on sort of where areas where things clash. That's why we will do a comparison at the end, see where they perhaps clash, because where it's similar to other things, we might not learn as much. So, starting with origins, in section 2, Dominating Concerns, title A, Origins. So the origins of debate, according to the author, addresses when and what capitalism is, or more often specific phrases such as industrial or financial capitalism, and when did they arise. What defines it, and what are its terms of art and key conceptual, technological, institutional, and practical elements. Two areas which do not converse very often have been dominant, as being legal histories of ideas and doctrines and economics histories. So these two areas that have managed to achieve research in this area, however, they've often been kept mutually exclusive. And the debate about the classical model of contract among legal histories might be read as a specialized instance of the debate about the origins of capitalism. So the concept itself of the classical model of contract may be a manifestation of the work to discover the origins of capitalism. Therefore, legal historians tend to resist swift moves between contract law and capitalism, and it's rooted in theories of law's partial autonomy, claims of indeterminacy, or commitments to complexity, multiplicity, or resistance to hegemonic ideologies and powers. So contracts have often been seen as kept outside of perhaps the political realm, to put it in one word. The classical model of contract, often interpreted as an idealist capitalist scheme reaching its zenith in the 19th century, and one pillar is the social order at the center in sphere of free competitive economic activity conducted by autonomous contracting individuals who are rational maximizers of economic interest, and it's founded on the clear divisions between public and private, and both vertically between the state and civil society, and horizontally between economic and intimate relations within society. So there are many verticals through which these origins can be studied, horizontally and vertically, and within each of those dimensions many layers as well. It's not necessarily laissez-faire, which is French obviously lead to do, but encourage economic competition and individual self-reliance. The judiciary is seen as a protector of rights with mutual respect among individuals and adequate spaces for self-realization. It's important to note at the core the clash between abstraction of free will and modeling of capitalist market. So that's sort of the core of this area of research, and the clash between protecting subjective positions and a market vision. Therefore, the classical model gave priority to the latter, which is the market vision. So that's sort of the origin of the market vision, one might call that. And therefore, the author asks, is the free market really free? Is another question that digs into origins of contracts and capitalist history. And the formulation of the will theory came from civilian jurisprudence at stake with two intertwined questions, periodization and causality. And therefore historians are split on whether classical model was revolutionary or evolutionary. So that's would be a tough debate. I would not prefer to take a side, but I say it's one of the two, and probably a little bit of both. And therefore the answers are bound up with casual explanations about its crystallization in the 19th century, those associated with critical legal studies such as Patrick Attia, Duncan Kennedy, and Roberto Unger, see the late 18th century, and even more so the 19th, as revolutionary. And the other camp, somewhat more divergent, including Brian Simpson, James Gordley, David Ibbotson, John Baker, Philip Hamburger, Warren Swain, and earlier figures like Frederick Maitland and Francis Montague, see classical model in periods much earlier than the late 18th and 19th century, therefore see it as evolutionary. And the myriad of explanations for the sense of newness which share in the internalist orientation. So perhaps maybe I think both are true, but I think it's probably more likely evolutionary because I think there's some existence before the creation. But nonetheless, both probably have truths. But I also note that the evolutionary camp, actually, the scholars listed actually date back earlier too, so that's something to note. And therefore, the author notes, for instance, selective assimilation of civilian influence by the English jurists and emergence of treatise literature which systemized the doctrines and became the first common law theory of contract, or the decline of the jury trial which pushed judges to articulate legal principles, the salience rather than newness. So this is sort of beefing up the evolution argument, or demonstrating the evolution argument. And economic historians seek to explain the emergent pattern of sustained growth in late modern Britain, and contracts seen as part of histories of trades, services, industries, and other contract-based activities. And therefore, it's a functional term, not as independent themes, or within broader debate of historical causes and turning points in the capitalist development. So I think that's an important way of noting that it's kind of, perhaps maybe too much so, some scholars try to make it seem like it was linear, but perhaps maybe it's not absolutely revolutionary, but maybe it's a little got some steps to it. So that's a very quick summarization of the origins. Now we will go to section B, distribution area of research. So alongside the debates about the origins of capitalism, its distributive effects have long preoccupied historians, and defined here not limited to economic capital, and it includes in this chapter cultural capital as well, and examines questions of social equality in gender as well as class terms, and sometimes in terms of group dimensions such as professions. In contrast histories, it unfolds through two more focused debates along the conceptual axis of late modern British history: status liberalism, the classical model of contract, and liberal welfarism, the conceptual axis and not necessarily temporal. and not committed to access as a matter of historical progression. One debate addresses the persistence of status hierarchies, and the latter, the socialization of contracts, both essentially debates about hegemony of the classical model of distributive scheme. So, starting with the first one, that is status liberalism. So, sorry, these are tough terms. They're tough for me, but nonetheless, I encourage you to, if you do not grasp everything here, as it's going by quick, and I encourage you to research it more, because I think these are fascinating areas if you're interested. I think well, there's a reason why in at least Western law schools the contracts courses are mandatory, or at least in North America, Canada and the U.S. It's mandatory courses. So I think it's important to study this. So without further ado, first, status liberalism. So conceptually, according to the author, the classical model established a distinction between status and contract. The latter represented a set of freely chosen, self-imposed obligations of abstract individuals, unlike status, which represented obligations imposed a priori, without an individual's consent, and pre-assigned social position based on ascribed characteristics. Henry Maine's formulation of the difference as progress remains unsurpassed. Here's a quote from Henry Maine. Not many of us are so unobservant as not to perceive that in innumerable cases where old law fixed a man's social position irreversibly at his birth, modern law allows him to create it for himself by convention. So in some ways, contract is a movement away from status. So for example, one might have been an aristocrat, and that would have been a perpetual thing, perhaps in olden day France. But nowadays, with new contracts, somebody could, with the right contracts, make themselves into a bigger landowner than anyone has ever seen, potentially. And therefore the question comes, has status really lost its day? Perhaps caused by contract. From the perspectives of contract doctrine, yes, according to the author. The legal thinking shifted from associating contractual rules with sets of relationships, such as landlord and tenant, master and servant, etc. So then these things were formed in contract, which also gives it a finite nature. Critical legal studies work has been particularly effective in showing how status has lost their operative power as sources for generation of legal rules and interpretation. And there is sometimes a sense of lament over the lost world of communal solidarity in the move away from statuses. So that's subjective, but for example, some people do miss, like for example, at the opening of Gone the Wind, at least the movie. I've not read the book, admittedly, but I do read many books, nonetheless, I hope one might believe. But nonetheless, in the opening of Gone the Wind, they say, no, I'll quote it wrong, but long are gone are the days of chivalry. So, for example, under those times where they did have great aristocrats and landowners, of course, there were slaves and things were hard for the vast majority of people, but they perhaps, according to the, well, at least the director and probably the author, they thought it was perhaps more placed for chivalry. But nonetheless, yet lament is a question of perspective, as the author shows to agree. Exclusion of domestic relations from contract law under classical model, for example. From perspectives of doctrine, exclusion radicalized contract as an arm's-length market relation that marginalizes communal and intimate ties, accordingly. Hostile picture, and therefore there's often a hostile picture of contracts. On the other side, feminist histories often recount efforts to introduce the language of contract and arm's-length equality into the patriarchal world, also hostile picture of statuses. So it kind of takes twofold. So the contracts are bad, but as are statuses too. So nonetheless, or did it reinforce statuses in some cases? For example, if the father gets all the estate, then that is a contract, for example, and that would strengthen the status as well. The other interpretive direction of histories concerned with the status liberalism axis reveals limits of classical contracts' victory. Such histories often focus on specific types of contracts central to modern capitalist orders such as credit, employment, or marriage, and reveal the viability of status ascriptions in Arab's liberal contracts, and show contractual practice, interpretation, and doctrine sustained a myriad of inequalities, from contract to status. Liberalizing or hierarchy supporting is, I guess, the rub. Did contracts liberalize people, or did they reinforce the hierarchy of statuses? I tend to think, over the grand scheme of things, it did have a liberalizing tendency, as we can see, but maybe statuses kind of disappeared on their own. So moving to number 2, liberalism welfare. So the second component, or the second dimension, the author notes in regards to distribution. Liberalism welfarism. So socialization, according to the author, implies the introduction of principles that acknowledge and correct power and information disparities, and more broadly introduce fairness, solidarity, and known dependencies into contracts. For those who see the classical model of contract as blindness to socio-economic disparities, the question was classical contract socialized? Here, there are both yes and no camps, and bears a clarifying debate can also be read through 2 different historical understandings of socialization that cut through these answers. In one group, historians who treat socialization as a matter of a linear timeline. First classical contract, then it was socialized, so that's sort of the linear timeline, essentially a history of the rise of the welfare state and of the welfare understanding of contracts in the second half of the 19th century. And the other group challenges the linearity of the narrative. One way by challenging retrospectively reading interdeterminacy into law and recognizing social elements within classical doctrine. Theoretical project known as internal critique of contract, which carries historical implications. So basically one is trying to linearize it and one is trying to show that it was pretty idiosyncratic, essentially. Many histories point to a gap between judicial practice and theory, so perhaps a lag somewhere, and former never becoming atomistic as theory was, or to complexities within judicial practice which was never wholly transformed to radical individualism. All speak to a level of socialization existing within contracts all along. So once again, we kind of see the existence before the existence. So with this, now we've discussed the linear versus nonlinear component. There's also so that's the 2 dimensions. So within the yes socialized camp, according to the author, can be read through dominant insights. One dialogue with the linear telling of the story of the fall of the classical contract describes historical efforts dating back from the mid-19th century onward to mitigate unwanted effects of unrestrained pursuit of self-interest, most reliant on state regulation, whether as a part of a radical or liberal political program. And no commentator since Albert Van Dicey has argued for a laissez-faire age or absence of state before the welfarist era. Rather, the story recovers a change in political sympathies and growing state administration, which led to a socialization of contracts. So I think one way of looking at the difference between perhaps the former status liberalism and liberal welfarism, or at least in this discussion, is that, and the one is the discussion of just generally was it liberalizing or hierarchy supporting, whereas the latter is did contracts itself get liberalized or not. Another socialization route is non-linear and emphasizes classical contracts' failure to achieve hegemony in the first place, pointing to significant social approaches to contract. Not socialized interpretive camp is implied in 3 dominant insights. First, in the dialogue with linear narrative suggests that if welfarism is viewed as a specific historical stage between the second half of the 19th century, the socialization of contracts well into the 20th century functioned as a palliative rather than alternative to the classical model. Both the consensual idea and the conceptual separations between private and public were maintained as cornerstones. And a point has been confirmed by virtually every historian who considered the question but not quite consistently conceived as a failure of socialization. However, the implication is that the category of contract itself remained little reformed by social law. The second, again, in a linear vein, some historians suggest that socialization was marginal in its effects and intentions dominated well into the 20th century by liberal rather than radical sentiments, and on some versions functioning as little more than market apologetics. The rise in the internal critique which found the social within classical contract is itself best understood as a theory rather than history of contract, which only began to be developed in the 20th century with the rise of legal realism. Thirdly, some historians point out that social alternatives were strongly resisted or overshadowed, such as Cornish and Clark argue that equity was not a real threat for most of the 19th century, and it became one at some point in time that legislative activity intensified in the welfarist direction, and case law responded by its individualist ideology. Other accounts speak to the mistrust of the state, such as Mark Steinberg. So as we can see, that's very non-linear. As a matter of emphasis, according to the author, debates about socialization, those being liberal welfarism as she coined, are often narrower in scope than those dealing with status liberalism, because their focus is mostly economic distribution rather than the broader question of identity of the cultural struggle that typifies histories concerned with status hierarchies. Yet, as discussions of capitalism largely interested in distributive justice, as Ellen Makeskins Wood said about the history of capitalism, how we understand history has a great effect on how we understand the thing itself. I think that was brilliantly said. And the next section, as we shall see, speculatively explores what contracts might tell us about capitalism beyond the now well-developed issues of origins and distribution. So, as people say that in law one doesn't need math, but as you progress in math you need to understand calculus, and to undersee all these dimensions I hope one or I think one requires to have quite a visual mind, but I kind of visualize it kind of like a at least, I don't know, tic-tac-toe sort of board, but with just many vertical axes and many horizontal axes. But then also one must have a visual mind, I think, to sort of get these all together. But I think if one were to really study this closely, a useful exercise would be to perhaps try putting these into a chart. Moving to section 3, contracts and capitalism redirected. So we will explore two possible routes, embodiment and nationalism. The foci are unexhausted by political economic questions of origins and distribution, and the former calls attention to the lived experience, and the latter calls attention to the circumscribed background assumption of debates about distribution. Once again, these being embodiment and nationalism. They are largely limited to distributive trends within the state political unit, and questions of origins sometimes touch history of nation-state but do not make it to the theoretical focus in relation to contracts. They are both revealing historical capitalist structures and logic and ultimately tied together into a broader picture of the capitalist order, both already embedded but require fleshing out, reconceptualization, and more research, but both are viable. So we will start with A, bodies, which is short for embodiment, as we shall see. And this will also be subdivided, and then we will move to nationalism across a few instances. So starting with A, bodies. Bodies studies are a multi and interdisciplinary endeavor pulling together a number of overlapping trajectories, according to the author. The material body to be fed and maintained, associated with industrial capitalism and classical political economies focused on production and reproduction, and the social body to be perfected, displayed, associated with consumer capitalism. Legal historical scholarship has been slower than normative and sociological legal scholarship in embracing embodiment as an analytical perspective, and contracts seem the least likely area and foremost the classical model given the dominance of abstraction at its core. But precisely for this reason, according to the author, it is apt for an exciting reconceptualization. So we will look at three trajectories within this embodiment or bodies category of the body in relation to capitalism in the late 18th and 19th centuries, which implicate contracts might be considered, with two major questions, one being the body as a locus of disempowerment and conversely empowerment, such as sexuality and labor and race, and clear cases of a disempowerment. And the second question, we will look at these three trajectories, are the problem of Cartesian dualism, conceptual separation of mind and body, and the identification as mind as an essence. So, starting with trajectory 1, titled The Body as Object of Exchange. And pardon me, I will even be, never mind. Body sale is a long-standing locus of debate about implications of capitalist exchange, and it is alienation of bodies as saleable commodities, a manifestation of structured subordination, or an instance of self-possession. So that's a very profound question. To meditate on it very briefly. So if you can sell your body, is it alienation of the body as a saleable commodity, or is it an instance of self-possession? So if you can sell your body, did you get ownership of it to begin with? And therefore, to trade in bodies can range from include body fluids, organs, and services like surrogacy to personal care and much else. Two contractual contexts identified as constitutive of capitalism: labor drawing on employees' bodies, so that's another form of selling body, labor power, and marriage drawing on a woman's sexuality. I might add, I think it's also possible for men, but yes, probably much more likely for women. In the classical contract theory, only the promise of marriage was theorized as a contract. Yet popular political debates routinely assumed that marriage raised questions of contract. Meanwhile, marriage, or more broadly, the traffic in women, was historically theorized as part of the capitalist economy by outsiders to economic theory and became a mainstay of feminist history. So these two tangents, within the trajectory, labor and marriage have respective boundary marks: the contractually enforceable relations of slavery and prostitution, respectively. Association of slaves and prostitutes were mere bodies implied that contract began when something more than the body was involved. Also, contracts in the mind exist too. Contracts to marry, premised on a female's sexual purity, and could be negated if that condition was violated. So a marriage contract could be removed if the woman, for example, engaged in adultery. And also helps to speak to the logic of capitalism. Increasingly, it's hard to commodify bodies without the embodied person's involvement as an agent. And for example, there's insurable interest. Emergent requirement essentially forbids contracting on lives unrelated to the insured in contracts to slaves and indentured laborers, where challenges of interpretation and enforcement of contracts led to abolition. In this regard, it's mostly disempowering, and the male body, on the other hand, which could be seen as a masculine features in contracts, are empowering. So a more, for example, strong person might be lower insured or something like that. Nonetheless, it seems from the author's perspective to be relatively disempowering for women and relatively empowering for men across this trajectory. Moving to the second trajectory, the body as a means of exchange. Putting your body, according to the author, on the line as implicit contractual guarantee was integral to the capitalist credit economy. For instance, it points to the body's role as one indicator of the working class debtor's creditworthiness. So one's healthy, one's more creditworthy. And notions of able-bodiedness undergirded financial support more broadly. About half the adult male population in 1950 were engaged in such contracts. Penelope Ismay shows how able-bodiedness became a factor in the structure that protected members from life cycle poverty. The logic later disappeared into the ideas of industriousness, a process which speaks to the disappearance of body as an openly acknowledged constitutive element in contracts. And the role of body as contractual guarantee becomes dramatic in history of imprisonment for debt. So if someone gets imprisoned for debt, but they can work it off, perhaps it becomes more complicated. And there's no longer been debtors' prisons since the late 18th and 19th century, which is a significant change, and viewed as a class story targeting working class. Also, it shows a shift in the body's gradual marginalization. Other issues, including general limited liability legislation, expansion of bankruptcy to consumers, the abolition of imprisonment for large debts, married women, separate property against which creditors could increasingly proceed. So that's I guess not disempowering, but a bad thing, unfortunately, for women. So, for example, if a married couple go engage in some kind of contract and they have to pay a debt and the husband dies, well, they can take it from the wife, unfortunately. And repeal, in many cases, and a repeal of imprisonment under the master servant laws. Reforms are limited to contractual enforcement against bodies. Often the Enlightenment trajectory is often perceived as well. And also included embodiment and an anti-Cartesian history of contract emerges. And that's René Descartes, which is one of my, I guess maybe one of the first philosophers that really excited me. When my advanced calculus teacher gave me a René Descartes quote many years ago, and I've since been fascinated in him, mostly because his fascination across different subjects, and depth within each. But nonetheless, moving to the third trajectory, the body as a driver of exchange. So Need recalls body, according to the author. Hunger for food or sex, pain, sickness, impending death. Desires involving the body as a locus of maintenance, cultivation, and adornment. And they resurrect a full array of options in capitalism, and they narrow down to thinking about particular areas of contract where indications of disappearing corporeality abound. For example, women are viewed as representation of unrestrained consumers, justified disciplinary responses to their contracts. I think that's obviously very wrong. Women are not unrestrained consumers, but nonetheless it seemed to have had an effect at some point of time in contracts, according to the author. Life insurance rooted in maritime pursuits invoked fear, and also advertising targeting the body and beauty, etc. There are countless examples of that. But nonetheless, this is another sort of, I think maybe analogous would be, this is the, I don't know which one it would fit better with, supply side or demand side, but whereas the other two would be supply side, this would be demand side. Or it could be put the other way around, whichever is better. But either way, I think trajectory 3 is just more distinct from the first two. So, and so this is all of the embodiment category. Moving to section B of part 2, titled Nationalism, and we will have 2 trajectories, and then we'll have a conclusion. So we're almost there. So, in addition to the engagement with the body, hints of nationalism in collective identity on principle of congruence with state political unit, like embodiment, not consistent conceptual lens. So the classical contract period coincided with changes in imperial scope. American independence, the European outbreak of peace, as Linda Coley calls it, and the ended warring of religiosity, and put pressure on the meeting of identity. So there's significant changes in this 18th and 19th centuries. The bureaucratic state increasingly was involved in civic life and was a 19th century legacy as we are coming of transportation and communication modes such as railway, telegraph, and new communication media, and undermined localism. And as well, the slow expansion of democracy turned more people into citizens. I think of this as kind of a sort of going back to Athens, where citizenship was so important, or same thing also with ancient Rome. Also the era, different periods of ancient Rome. Also the era of globalizing capitalism, free trade policies, and expanding systems of international trade, international legal harmonization as well. As someone who is very fascinated in international law and has been fortunate to spend time working in it, and contracts here are interesting as not specifically English or British attributes. And so the author notes they're not specifically English or British, and as it did on male and the middle class ones as well. As the author sees it, it had civil law roots. The liberal remains at the margins of discussion, so sort of going to complete other direction, whereas it had a liberalizing effect, perhaps it has sort of a nationalizing effect. And liberal remains on the margins of discussion. The nationalist character of private law is usually associated with codification projects, such as Corpus of Juris by Justinian, or the French Civil Code, German Civil Code. And common law does not have its own claim to deep-rooted national character, yet contract law specifically has not been an object of examination. So contract law is sort of the most common, or in common law is seen as common law, but from a fascinating way of putting it, for her, it seems like a civil law thing, especially considering it's between people. But there's also the civil law, as we call it, in common law jurisdictions, which is actually between people as well. So I think it's very eye-opening, and it could be meditated on for much time. And there are 2 perspectives. They're from within, the harmonization of the local legal cultures leading to nationalism, and from without, the difference maintenance leading to nationalism as well. And contract's role in constituting national differences and making borders, real or imagined, matter in global capitalist trade. So starting with the first trajectory within nationalism, the inside borders, national harmonization. So theoretically, according to the author, Benedict Anderson's classic theory of imagined communities is an apt starting point. He turned on a forged relation among strangers who learned to experience a community characterized by being horizontal, secular, within an empty, homogeneous time measured by calendar and clock. The classical model of contracts, moving from formal equality to perfect fit, and in doctrinal the doctrinal content, innovations would characterize expanding networks of trade and credit, shortened spatio-temporal distances, arguably important for the national consciousness. So having these contracts has sort of brought people together, and this is sort of an internal force strengthening nationalism, supposedly. An example for the postal rule. So that's something huge innovation, particularly in the United States, and I would say particularly under Benjamin Franklin, who was Postmaster General. And contract formed upon posting a letter of acceptance, brought closer together and fair. So once you can trust that your package can make it somewhere, you kind of they come into your family almost, and therefore brought a national consciousness. Therefore, there's also creditworthiness, which reduced anonymity that to threaten developments for bringing strangers into economic contact. So now if you know someone's credit score, it's like, oh, it's trustworthy, let's do business, vice versa. But nonetheless strengthens the nation, or the nationalism supposedly, and formed national imagined harmonious community. And there are two significant court reforms the author mentions in the 19th century: the 1846 establishment of county courts, which superseded a network of local courts, and communal justice, and largely dealt with contractual consumer debts, and the 1873 to 1875 Judicature Acts, and which unified the common law courts with the courts of chancery and brought the common law's classical model to national dominance, therefore overcoming differences and forging a capitalist nation. There were also labor contracts, which brought people together, which are the opposite of dependence, supposedly, and therefore contracts led to the citizenship, as we can see. So sort of a nationalism from the internal. So moving to the second trajectory, from the external forces, outside boundaries, difference maintenance. So the author asks, did contracts have a role in constituting and maintaining national borders? One entry point to the question is prevalent distinction between contract and status, as previously discussed. Maine's influence on British imperial policy shows the opposition between contract and status underlay an emergent view of the foundational differences between people and the transformed practices of imperial rule. In a similar vein, research on the emancipation of British colonies shows that the move from slave to contractual labor was conditioned on a priori acculturation into the capitalist ethos. Therefore, there are moral hazards as well. Robin Pearson shows English insurers have difficulty in assessing riskiness of Irish drinking habits, particularly on the cultural boundaries between convivial social tipping and alcoholism. And therefore, there's need for nuances. So therefore, for example, the English are not sure what to do about the Irish, perhaps maybe creates a difference. Maybe they don't want to do business with the Irish. Maybe they don't want to sell them alcohol because they don't know what they'll do with it. And more trust usually for domestic contracts too. So for example, a United States company might prefer to do business with a United States company because there's more perhaps strength within for them with the contracts. And the differences too in expertise in writing contracts. Some countries are better at making and better at enforcing contracts. And now organizations such as the International Chamber of Commerce, called the ICC, not the International Criminal Court where I was fortunate to work, but the International Chamber of Commerce, to have been created to address this, but it's still force of uniting nationalism and sort of supposedly contracts according to this trajectory. And the effects of print capitalism, language and capitalism contracts are converging. So there's also the argument to say that perhaps these borders are getting broken down with things such as the International Chamber of Commerce. So that is at least I found to be a lot of information. Actually, it is the longest chapter, so I apologize for going through it so quick, but nonetheless, and I said I wouldn't apologize, but I did it, so I apologize for apologizing. So the conclusion: the robust perspectives on when and what of late modern capitalism is as viewed through contracts and on distributive effects are a consequence of decades of historical work. Yet origins and distribution are not the only concerns to be addressed, according to the author. As contracts become the taken-for-granted infrastructure of capitalism, both functional and conceptual, they implicated additional levels of capitalist life, among them embodied experiences and national consciousness, issues that historians of contracts engage only at the margins. This chapter pulled out some threads to gesture the possibilities. In that sense, the future of contracts history still lies ahead. So I think a fascinating chapter, so many dimensions to look at, and as someone, admittedly, contracts were not, for the longest time I had very little interest in contracts, despite having an interest in business and finance. Contracts were less exciting to me, but looking at the way they influence nationalism, how they've been influenced and influenced liberalism or welfarism is absolutely fascinating to me. So I thank Anat Rosenberg for creating this fascinating chapter that instilled in me a passion for something that I had not otherwise had. So, to briefly go through the slide before we move to the next chapter. So, the position of Anat Rosenberg, she's a professor at the Reichman University Harry Reisner Law School. The three logos we have in the top right we have the Hebrew University, where she received her Bachelor of Law. In the middle, we have Tel Aviv University, where she received her PhD in 2011. And on the left, we have Reichman University, where she works at the Reisner Law School. Her areas of expertise include history of consumer capitalism in late modernity, liberal thought in late modernity, liberalism critique, particularly roles of class and gender in liberalism, cultural legal history, international law and literature, contract law, consumer credit, advertising law, marriage promises, Victorian and fin de siècle England. The quotes, I have two quotes here because unfortunately I was having some difficulties fitting. Normally I do three, but nonetheless I think because maybe we talked about it longer, because it's a longer chapter, maybe it's justified, but nonetheless I apologize to Anat Rosenberg, and I wish I could have provided another quote. So first quote, contract histories are inextricable from the history of capitalism. Not only functionally is capitalist life dependent on contracts for labor, capital, and consumer goods and services, but conceptually too. So very concise sort of value of contracts. And second quote, the robust perspectives of when and what of late modern capitalism as viewed through contracts and on its distributive effects are a consequence of decades of historical work, yet origins and distribution are not the only concerns to be addressed. And as we've seen, those are very important, but there are many others and many other trajectories to look at within. So once again, this chapter is in part 5 of the Oxford Handbook of Legal History, titled Illustrations, Doing Things with Legal History, and it is chapter 49, titled What Do Contracts History Tell Us About Capitalism, From Origins and Distribution to the Body and the Nation. So moving to the next chapter by Arlie Loughnan. It is in section 5 of the Oxford Handbook of Legal History, titled Illustrations, Doing Things with Legal History, and it is chapter 50 of the Oxford Handbook of Legal History, titled Historical Analysis in Criminal Law, a Counter-History of Criminal Trial Verdicts, and as we will call it, Criminal Law 2, because it is the second chapter on criminal law, specifically focused on criminal law. However, in no way, shape, or form does it follow second chronologically or overlap in any way. So, nonetheless, brief biography of Arlie Loughnan, which might be useful in our comparison, which will follow in the start of Plutarch's Lives after this chapter. She received her Bachelor of Arts with honors and her Bachelor of Law with honors from the University of Sydney, her Master of Law from New York University, and her PhD from the London School of Economics. She is a professor of criminal law and criminal law theory at the University of Sydney Law School, and her research concerns criminal law and criminal justice system. Her particular interests are constructions of criminal responsibility and non-responsibility, the interaction of legal and expert medical knowledge, and the historical development of criminal law. And some of her books include Criminal Laws, Material and Commentary on the Criminal Law and Process of New South Wales, 7th edition, published by the Federation Press in 2020, and another book, Self, Others, and State Relations of Criminal Responsibility, published by the Cambridge University Press in 2020. She is also the co-director of criminology at the University of Sydney, the co-editor of Sydney Law Review from 2013 to 2017, and the co-editor of the Institute of Criminology's journal, Current Issues in Criminal Justice from 2011 to 2014. She's also currently on the editorial board of both publications. She is an academic member of the New South Wales Law Society's Criminal Law Committee from 2009 to 2013, and an academic member of the New South Wales Bar's Professional Conduct Committee, number 2, and in 2010 served as the member of the panel of the expert advisors of the New South Wales Law Reform Commission, reference on complicity, and held visiting professorships at Cambridge University in 2015, the University of Melbourne in 2014, and the University College London in 2013, and at the Institute of Advanced Legal Studies in 2013, and the London School of Economics in 2010. So worked in many great places and a very accomplished scholar, at least professionally, and as we shall see in terms of her writing as well. So starting with section 1, her introduction. So she notes she would like to thank Mark Cohen, Kevin Crosby, Marcus Dubber, one of the editors of the Oxford Handbook of Legal History, and Chloe Kennedy for the comments on an earlier version of the chapter, as well as Andrew Chappelle, Natalie Sapasky, and Louisa Vopel for their research assistance. So the author notes in her introduction, historical analysis in criminal law is experiencing a recent flowering. Scholarly work takes seriously the temporal, institutional, and other conditions of possibility of the development of criminal law rules and practices. Scholars have adopted historical research methods and allied methods such as socio-legal studies to develop fascinating and provocative accounts of issues of criminal law, including the key issues of criminal responsibility and criminalization. In the growing body of work, responsibility for crime and criminalization of conduct are understood not as thin or abstract products of certain rules or moral norms, as in the case of legal philosophical analysis of criminal law, the type of scholarship inspired by normative philosophical thinking, but as complex or thick as complex sets of practices that take place in particular contexts and at particular moments of time. So that's one way of looking at the history of criminal law. The historical analysis in criminal law, according to the author, may be organized into several broad strands. First, comprises work in close dialogue with legal philosophical analysis, and which exposes the limitations of and contingencies in the analysis. For example, Nicola Lacey's work on criminal responsibility, and focus less on is and ask what it is for. Second strand of historical analysis consists of works that offer alternative methods of historical inquiry. For example, Lindsay Farmer's scholarship on criminalization inquiry, not framed by interest in which principles should guide the determination of the appropriate reach and limits of criminal law, but by prior question, how is it that the question of criminalization has come to be framed in these terms? And third strand seeks to contextualize major developments in criminal law and process by presenting close and careful accounts of change over time. Across these three strands, historical analysis in criminal law deploys diverse methodological approaches, including social history and legal biography, and draw on a wide range of primary sources, including literary sources, historical archives, and cultural materials. So, as one might guess, I think criminal law is, I'm not sure how the numbers check out, but one of the most popular areas of scholarship, and as we can see, there are many ways already to look at it. The fourth strand of historical analysis in criminal law is what we can call counter-history, which will be the focus of this chapter, understood in a broad way as the sort of scholarship that challenges dominant narratives about historical development of criminal law, and focuses on paths not taken at significant junctures in development of criminal law, and offers alternative narratives of legal developments via a focus on otherwise occluded aspects of the development of law over time. So I think this counter-history could be applied to many other fields as well, but I think it's particularly meritorious in criminal law because we kind of sort of had a chapter on criminal law, and now we can do the counter-history, which if you're watching this first, I hope I think this is just maybe even the better one to watch first. And like work falling within other strands may serve various aims, including developing alternative methods of an analytical inquiry and contextualizing development in criminal law and process. But such work offers novel and creative means to advance knowledge. The chapter presents an analysis that falls into the fourth strand and offers a counter-history of criminal law trial verdicts, restoring the special verdicts, finding of fact where a jury fails to conclude questions of law. According to typical story, general verdicts such as guilty or not guilty, a determination of both factual and legal issues at trial is thought to be both inevitable and right. So general verdict is guilty, not guilty, as we normally see, but special verdicts is finding a fact where the jury fails to conclude questions of law. And as we will see, and as the author will show, it sometimes benefits the jury, sometimes it benefits, or sometimes it's invoked by the jury, and sometimes it's invoked by the judge. And while special verdicts, they caused it nonetheless, while special verdicts, virtually unknown in English trial process during the period of the development of modern criminal trial, played a greater role in the process, functioning as a means by which the seismic changes associated with the appearance of modern criminal trial were negotiated in the courtroom, bringing to light the all but forgotten past of trial verdicts, opens the way to think about verdicts in the current era, considering the possibilities for the restoration of a meaningful role of special verdicts. So kind of looking at the path not taken, which is special verdicts, which are now very uncommonly used. So moving to section 2, the modern criminal trial and general verdict. So the modern criminal trial and general verdict. The modern adversarial criminal trial developed over the long 18th century, according to the author, the period from the end of the 1600s up to the first decade of the 1800s. The development entailed major changes in the relationship between actors in criminal courtroom and a significant development of legal principles and radical changes to practices of evidence and proof. Many hallmarks of adversarial trial appeared in the 1700s. These included the involvement of prosecution and defense counsel. So before 1700s, there were not even prosecution and defense counsels, properly speaking, although the latter had limited role until the 19th century. So it's surprising, at least, or was surprising at least to me, how modern the modern trial really is. It's only maybe a couple hundred, maybe 300 years old max, depending on where you want to consider it complete, and it's still changing to this day. A distinction between facts and law, and the rudiments of laws of evidence of process all came over time. During the century, increasing presence of prosecution and defense counsels gave more structure to criminal trials, which encouraged evidential objections and recognition of the burdens of proof. And the development brought trained legal counsel rather than judges and defendants to be the foreground and paved the way for the modern mode of trial as we see it today. The adversary trial. So I'm working on a trial now, and it really is quite adversarial. It's like maybe perhaps you can be friends after, but during the trial you are on opposite sides, in which the defense tests the prosecution case. The appearance of the modern criminal trial is a political development, but I do note I'm not, this is not a criminal trial. I'm working on, nonetheless, but nonetheless it's still adversarial, whether it's criminal or not. And it might end up being criminal, we shall see. But I don't know if I can share this anyways. Appearance of the modern criminal trial is a political development, supposedly, and took shape against the backdrop of the late 18th century constitutional struggles concerning religious and political freedoms. At the forefront of the struggles because the political opponents were dealt with via criminal law, and trial by jury was implicated in debates about constitutional freedoms. So that's an interesting thing to note, that of course criminal law was related to political changes, because at the most violent form goes to criminal law and criminal proceedings. So when it really gets heated, it does become criminal. And most prominently, the series of high-profile criminal prosecutions of the Quakers in the 1660s, where recalcitrant juries refused to convict, were fined. And in Bushnell's case in 1670 established the principle that jurors could not be threatened or punished for their verdicts. Thank God for that now. And reflected and advanced the wider politicization of criminal trial by jury, heralded by sustained period in which relationship between criminal trial judges and juries was much debated and contested. The development brought about the dominance of the general verdict, guilty or not guilty, and caused the necessity of greater control of the jury, especially as the increase of the number of capital offenses in the long 18th century increased, and general verdict protection from tyranny cemented its dominance. The special verdicts deserve more careful consideration and include statements of fact, and fail to conclude questions of law became a feature of the criminal trial process in the medieval era, they presented a way of dealing with matters of justification and excuse in cases of homicide, which were all tried as murder. So sort of it originally was a way of giving a more nuanced verdict, and over time came to be used for a variety of purposes. In the 17th century, Lord Coke, one of the greatest lawyers, supposedly according to one of the previous authors, stated that jurors are best placed to advise the judge on the facts, and the special verdict presented the ideal type of verdict for the judge-jury relationship. Sir Matthew Hale referred to the value of special verdicts in trials for murder, where accused killed for special defense or as a result of innocence. So Sir Matthew Hale is also absolutely a leading English lawyer in England during this era, and remained a familiar, if relatively uncommon, result of the criminal trial process in the long 18th century. and suggests they're regarded as a legitimate option for the judge and jury in criminal trial process. The counter-history of trial verdicts restores the place of special verdicts in the story of the trial process and opens up the consideration of their potential part in the criminal trial process in the current era. So this counter-history, why is it not as common now, and what caused it, and why did we end up here? In the current era, special verdicts have been returned in only a handful of trials in England and Wales over recent decades, and been held that they ought to be found only in the most exceptional circumstances. For example, an R.B. born in 1952, rather than a legitimate option for the judge and jury on the basis of trial, should result in a standard general verdict, given the status of special verdicts. So they're sort of subordinated and very uncommonly used. And given the change in status of special verdict changed profoundly from the time of Coke and Hale, who thought it was absolutely fantastic, and now Hartley Hughes, we can ask, under what conditions were special verdicts a useful outcome of a criminal process? And is it possible to envisage a meaningful role for special verdicts once again? So moving to section 3, titled Reclaiming Special Verdicts. So the author notes, special verdicts function as a means by which the seismic changes associated with the development of the modern criminal trial were negotiated in the courtroom. Study of the records of the Old Bailey proceedings will be shortened here, OBPs. I think the Old Bailey, the first time I heard of it was actually in Tale of Two Cities. That's where the first trial takes place, so it's kind of has a particular image in my head, and shows and smells and such, and shows deployed by various actors for various purposes in a way that indicates that served at diverse interests and functions. And therefore in this chapter we will discuss 3 main functions: accommodating the changing division of labors between actors in the criminal courtroom, 2, negotiating the formalization of criminal legal principles, and 3, facilitating the acceptance of the modern legal practices of evidence and proof in the criminal trial. So starting with A, or the first of 3, titled Accommodating the Changing Division of Labor Between Actors in the Criminal Courtroom. So development, according to the author, of the modern criminal trial entailed major changes in the division of labor between actors in the criminal courtroom. In this context, it was deployed by both judge and juries as a way of accruing and divesting power in the courtroom, as I previously alluded to. Seemingly contradictory uses reflected the fluidity of the roles of judges and juries in this period, and the adjustment required as lawyers entered the courtroom and an emergent appellate review process came to sit above the adjudication at trial. So these 2 factors: firstly, the greater significance of lawyers, and also the process of appellate courts had played effects here. Even as the power diminished over the course of the 1700s, judges dominated criminal trials and could do a great deal to assist a prisoner if he chose. Alongside the more familiar and narrow construction of criminal law, directing the jury to a special verdict enabled judges to take control of the trial outcome. Direction to bring it to special, it was often referred to in the OBPs, occurred in 2 kinds of cases. First concerned the point of law arising in the matter, such perverting justice. The jury considered the matter and brought him in guilty of the fact, but the court, being of opinion that some point of law could arise, directed the jury to find it special, and they did, such as in forgery, and the latter case, forgery, and a point of law arising, the court directed the jury to bring it in special. Also in murder, some points of law arising from evidence, the jury gave in a special verdict. So these are actually quite a few ways at this time the special verdict was invoked. And the second kind of case featured in judicial directions to the jury in return a special verdict concerned those cases in which question arose as to whether all the requisite elements of the offense had been proved, whether under all circumstances of the case it amounts to murder or not, whether there had been taking and carrying away of property as required of the offense of larceny. So in this case, sort of the judges are putting into special to take away the sort of the risk of the juries having the too much of a say. Like judges, however, juries also use the special verdict as a means to accumulate power in the courtroom, reflecting the already established tradition of merciful application of the law by juries. Juries use special verdict to temper the harshness of criminal law. although it did not prevent a prisoner from being tried and convicted at a later time. So they could be, although they put it into special to sort of soften, they could still get it later. A chance prisoner would be reprieved. Less well known that partial verdicts convicting on a lesser charge seem to have an important merciful tool for the jury. So sort of, once again, so this is the jury sort of gaining power by using the special verdict as a merciful tool. For example, Mary Anson's 1769 trial for manslaughter of her husband by biting his little finger. After amputation, he died. We have the greatest reason, the jury wrote, to support he might have died by a scratch of a pin, as he was in so bad habit of body. And combined with the possibility of a prisoner responding to violence from her husband when the finger was bit, the jury attempted to, at leniency, provides some explanation of the special, and several other special verdicts that similarly represented jury's temper of the law. So, once again, the special verdict is used both by the judges and both by the juries to sort of gain power. Division of labor between judges and juries was altered by the appearance of the defense and prosecution counsel from the early decades of the 1700s. At this time, the role of defense counsel was still emerging and could not address the jury or offer a defense, but could cross-examine prosecution witnesses, so limited scope at this time. And government had only begun to pay prosecutors who secured convictions in ordinary felony trials and to engage lawyers to ensure certain cases were prosecuted effectively. So even on the prosecution side, it wasn't even that properly formed. This was the context for those special verdicts that appear to have been initiated by counsel. The technical nature of forgery seems to have invited such close argument and produced quite a few special verdicts. So these underlying changes. At the same time, juries and judges utilized special verdicts as a means to accumulate power in the courtroom. They also appears to have been deployed by both to divest themselves of decisions. For example, assigning the task of determining whether something was a felony or a misdemeanor, which involved determination of whether accused would face a capital punishment, juries left to the judge. So the special verdict, they didn't want to have blood on their hands, to put it bluntly. And also, when facts were unclear, they also used it. Also in cases of unlawful killing, murder, or manslaughter. Judges too used this, however, such as to send a matter for review, and even justices of the peace. Deployment of the special verdict fed into the development of a nascent practice of judicial review and may have aided doctrinal development of common law by providing a space for judges to discuss law. So perhaps, so when they called a special verdict to have put it to someone else to review, maybe that was what ultimately caused judicial review, or the appellate court system as we have it today, in at least Canada and the US and many other geographies. The option of the special verdict meant challenging questions of law could be left to a bench of 12 justices for consideration, so also this dialogue between justices. Also, judges appear to have directed jury to return a special verdict in a number of instances in which they sought the opinion of 12 judges, and special verdicts acted as a means of bringing particular cases to the attention of the review body and relieving the judge the responsibility of making controversial decisions. Difficult or controversial decisions. So, special verdict was used by both judges and juries to gain and divest power, to put it in the fewest words possible. So, moving to section B, or the second trajectory, perhaps we'll call it, negotiating the formalization of legal principles. So, development of the modern criminal trial, according to the author, brought formalization of criminal legal principles, according to which key legal principles such as conduct and fault were subject to conceptual elaboration. In the long 18th century, this process of formalization included early development of two closely related dimensions of criminal fault: the factualization of mens rea and elaboration of the subjective pattern of criminality, whereby the defendant's intent became the central question in assessing liability. So this is a huge change in the legal way of viewing criminal cases at the time. Special verdicts played a role in negotiations of these two changes in legal principles in the criminal courtroom. At the beginning of the period of the long 18th century, the notion of criminal fault was largely undeveloped, as fault was assumed and not subject to investigation at trial. As Lillian Farmer previously mentioned and argues, fault based on wrongfulness of act, and because legal guilt was equivalent to moral wrong, the degree of intention of the actor did not have to be explicitly proved as a condition of liability. As statutory offenses, some of which contained an express fault element, were introduced in increasing numbers in the 1700s, it became necessary to prove fault specifically. So with these new sort of laws that required a fault element, they're needed to prove fault in the courtroom. Development depended on factualization of mens rea process, by which interior mental states came to be regarded as amenable to proof as a question of fact. Factualization of mens rea was part of a broader development according to which fault came to be identified as an express dimension of criminal offenses and an essential aspect of the prosecution case. As Nicola Lacey argues, factualization of mens rea formed the basis of the subsequent development of a primary capacity-based and heavily psychological notion of mens rea that marked the core of the late modern general part of criminal law. Special verdicts played a role in negotiating or perhaps institutionalizing mens rea. For example, Robert Munday's 1799 case deferred to a special verdict to determine whether contract made before stealing 200 pounds of lead, or Thomas Field in 1785 whether removal of a stamp and sold it for the what purpose was it removed, and therefore mens rea was incorporated through the special verdict. Other major change on the level of the legal principle in the long 18th century, the gradual and piecemeal elaboration of subjective pattern of criminality, which depended on factualization of mens rea, orienting conception of fault around legal evaluation around what the individual knew, perceived, and or intended the time of the offense, and emerged at the end of the 18th century and is emblematic in modern criminal law, and change in the focus on a broad movement from the ideas of responsibility as founded in character to conception of responsibility as founded in capacity. This concept of capacity responsibility is also a subjective one and linked to changes in the state and social organizations such as organized policing, and the rise in subjectivism also reflected in turn enhanced by more finely tuned grading of offenses according to culpability, and in the OBP records reveal historical existence of two appropriately included among special verdicts, although later subsumed into more formalized defense categories: verdict that killing occurred se defendo, in self-defense, or per misinfortunam, or per infortuniam, by accident, and Lord Hale identified as special verdicts. So sort of they used the special verdict to sort of get at this mens rea when it wasn't explicitly in the laws. And it indicated would the alleged murder up to a defendant to provide the evidence not murder, prima facie murder, found the matter special. So there's this. So, but maybe because now many of these laws do include this mens rea component, maybe the special verdict is less necessary. The author does not explicitly say that, but I think she alludes to it. Moving to C, or the third trajectory, facilitating the acceptance of modern practices of evidence and proof. Development of modern criminal trial, according to the author, entailed a revolution in evidence and proof. Special verdicts facilitated this revolution, helping smooth the way towards high standard of proof that was coming to be required in criminal trials and demarcate the then still solidifying boundary between law and fact. The relation of proof during the long 18th century marked a transition from the altercation trial, which was an adjudicated process centered on the idea of direct confrontation of the accused with his or her charge as the best means of discovering the truth, to the adversarial trial, familiar in the current era. Since 1700, proof gradually became internal to the legal proceedings. By the end of the century, references to beyond a reasonable doubt standard had appeared, so the shift from the altercation trial to the adversarial trial. The key perhaps was influenced by the special verdict, or at least influenced the special verdict, and the presumption of innocence crystallized by the end of the 1700s, but before was widely accepted that any doubts about the case should be resolved in the accused's favor. Shift in the OBPs to jury to view all matters in special circumstances necessarily considered. Sometimes we know not, therefore it would lead to a special verdict, but maybe it's not as necessary anymore, as perhaps the author is alluding to, or at least that's what I seem to feel. The distinction between the fact and law firmed also over this period, along with the changing division of the courtroom labor. But still, whether the jury found or merely applied the law subject to debate whether men could know the law was the question. And it continues to be a live issue. So, for example, can we use juries if they don't know the law? And lurked behind the 18th century criminal existence. An established tradition that part of the jury's role was to be merciful generated anxiety and debate about whether exercising the role amounted to law finding, and came to a head in the last decades of the 18th century in relation to common law offenses of seditious libel, the intentional publication of material that scandalized the government, that has subverted its authority, political and religious conflicts that generated trials for seditious libel in this period meant that they were subject to a high level of interest. Jury central as a question of whether seditious was regarded as a matter of law, and intentionally published the writing and bore meaning alleged by the prosecution known as innuendo, and became a lightning rod for debates taking place both within the Parliament about free speech and press, scope of the role of jury, its autonomy, and its place in the English Constitution. So in many ways the special verdict sort of at least was alongside the change of what is the role of the courtroom. Are they trying to find law? Are they trying to show the law to the jury? Are the jury supposed to be the judges? Are they supposed to be the lawyers? Or are they supposed to just see the information? Which I think the latter is sort of the more likely true answer, or the most likely agreed upon today. Special verdicts, according to the author, were the heart of the controversy surrounding seditious libel, although their significance was obscured, thus at the center of the then solidifying boundary between law and fact, such that juries had to return a guilty verdict even if they thought the publication was harmless or the accused did not have any seditious intent. Alternatively, forced into nullifying the law by finding the defendant not guilty even in the force proof of the publication. So it was kind of, perhaps the special verdict was used as a way to, and they don't want to ruin the law, but they see that it doesn't really apply in this area. The questions of fact were cast as questions of law, and general verdicts in effect masked particular findings of fact, with the jury asked to render what amounted to a special verdict in the form of a general verdict. So perhaps actually maybe it's the other way around, and that the general verdict could mask it. They all vote not guilty, even though they don't have to, even though they perhaps should have been guilty, they can kind of mask it by the general verdict, guilty or not guilty. In a special verdict, there needs to be further justification. In seditious libel trials, the role of the jury was tightly circumscribed, provoking consternation and placing additional pressure on trial verdicts, culminated in the passage of the Fox Libel Act in 1972 and associated with the widespread acceptance in England of the principle of freedom of political communication, and marked formal installation of the idea that political expression should be relatively unhindered, and presented as a declaration of common law rather than attempt to change it, but alter the relationship between fact and law in seditious libel. The act provided that judges were to give directions to the jury in like manner as in other criminal cases, and did not specifically state that questions of intent or seditiousness were to be understood as questions of fact, but affirmed the jury's right to return a general verdict, and interpreted as an admission that discretionary lay fact-finding was central to the administration of justice, a vindication of the historical role of the jury as a safeguard. So a lot of information there, but essentially the special verdict is perhaps in some ways embedded in our modern general verdict system, or perhaps in many ways it influenced it as well. So moving to section 4, which is the last section, it takes place as the conclusion as well. So titled History and the Counter-History of Criminal Law. This chapter, according to the author, presented a counter-history of trial verdicts, restoring the place of special verdicts in the story, While the now virtually unknown period of the development of the modern criminal trial played a greater role as a means by which the seismic changes associated with the development of the modern criminal trial were negotiated in the courtroom, it involved a study of the special verdicts in the OBP, shows deployed by various actors and for various purposes in ways that indicate diverse interests and functions, which I see both by the judges, both by the juries, both to gain and both to lose power, and cast a fresh critical perspective. In the era of the ever-increasing complexity in criminal law, special verdict might be thought to represent a welcome recalibration of the relationship between judge and jury, and conclusions of law and of fact in favor of newly sharp and clear boundaries of demarcations. Also, while formalized rules of evidence and proof that developed in the 19th century, which now govern the process, are aimed at restraining the potential of the jury to err, and errors do occur, the focus on particular facts in issue that is entailed in special verdicts seems to present a valuable option for ensuring the accuracy and fairness in trial processes. So the author here is advocating that perhaps if we brought back the special verdict, or use it more often, it might show a little bit more transparency. Additionally, viewed in the light of more and more elaborate laws on sentencing and recurring questions of lay involvement in deciding punishment, the special verdicts may be seen as a way of enhancing the communicative power of the trial verdicts. So I do see there are a lot of benefits, but maybe it might be too complicated to with the amount of cases we have going on today. It has been suggested that the general verdict, according to the author, the great procedural opiate, is valued for what it does, covering up errors rather than for what it is. So it's kind of in some ways a mask. And peculiarly has been said to be the merger into a single indivisible residuum of all matters, however numerous, whether of law or fact. So at the end of the day, all this has been said, guilty or not guilty. It becomes binary. Inarticulateness of general verdict is infamous and perhaps increasingly untenable. In contrast between the special and general may reveal that the latter are odd. So it's strange that we actually came to use the general verdict way more common than the special verdict. Historical analysis in criminal law, according to the author, represents a rich and expanding scholarly terrain. This chapter presented a strand of historical analysis in criminal law, counter-history, which I hope that you might use in criminal law, but also in other areas of research too. Counter-history, focusing on paths not taken at significant junctures in the development of criminal law. Counter-history represents a distinctive and valuable addition to historical analysis, encouraging legal scholars to take seriously the cul-de-sacs as well as the apparently straight roads we find in development of criminal law. And like the most innovative and sophisticated contributions that fall within the wider set of historical analysis in criminal law, counter-history invites us to think about received historical wisdom, opens up possibilities for rethinking the present, and goes towards encouraging us to imagine counter futures. It's a very, very fascinating chapter. I've always been fascinated in criminal law, but this area, in this particularly special verdicts and general verdicts, I never really focused too much on these two areas. And furthermore, the whole concept of using counter history I think is brilliant and brilliantly applied here. So thank you very much, Arlie Loughnan, for this beautiful chapter. So we'll quickly go through the slide content here before we go to a comparison with Anat Rosenberg. So Arlie Loughnan's position is a professor of criminal law and criminal law. Pardon me, I wrote that twice. Professor of criminal law. She's also the associate dean of research at the institution, the University of Sydney Law School. Her research interests include criminal law and theory, mental incapacity, and legal history, and many other things we might be able to add too. But those are broad categories, but she has extensive expertise in all these areas. Her suggested readings and her books include Criminal Laws, Materials and Commentary on Criminal Law and Process of New South Wales, 7th edition, with D. Brown, D. Ferrier, and L. McNamara, published by the Federation Press in 2020. Next book, Self, Others, and the State, The Relations of Criminal Responsibility, published by Cambridge University Press in 2020. And Waller and Williams, Criminal Trial Text and Cases, 12th edition, with T. Anthony, P. Crofts, T. Crofts, and S. Gray, published by LexisNexis in 2013. In terms of the logo, we have a slightly different order than usual because in the top In the top left, we have the institution she works at, but it's also the institution she received her first degree, which is, don't mess this up, we have which is the University of Sydney. So it is in the top left because that's where I usually put the most recent, but it also could be the first, but I didn't want to have it twice. So that's the University of Sydney in the top left. In the bottom right, we have New York University logo, where she received her Master of Law, and to confirm, at the University of Sydney, she received her Bachelor of Arts and her Bachelor of Law, both of honors, with honors. And in the top right, we have the symbol of the shield of the London School of Economics, where she received her PhD. In terms of the quotes, we have 3 quotes here. First quote, historical analysis in criminal law is experiencing a recent flowering. Such scholarly work takes seriously the temporal, institutional, and other conditions of possibility of the development of criminal law rules and practices. Second and next quote, in this growing body of work, responsibility for crime and the criminalization of conduct are understood not as thin or abstract products of certain rules or moral norms, but as complex sets of practices that take place in particular contexts at particular moments in time. And third and last quote, and like the most innovative and sophisticated contributions that fall within the wider set of historical analysis in criminal law, counter-history invites us to think again about received wisdom. Historical wisdom opens up possibilities for rethinking the present and perhaps goes some way towards encouraging us to imagine counter-futures. So I think that's also brilliantly written. Counter-history to counter-future. Seems natural. Once again, her chapter is in part 5, Illustrations, Doing Things with Legal History, in the Oxford Handbook of Legal History, and it is in the same book, chapter 50, Historical Analysis in Criminal Law, A Counter-History of Criminal Trial Verdicts, by Arlie Loughnan. So, a comparison in the style of Plutarch's Lives. So, starting with education, I suppose, Anat Rosenberg is the Harry Radzner Law School professor at the Reichman University in Israel, whereas Arlie Loughnan is a professor of criminal law and criminal law theory and the Associate Dean of Research at the University of Sydney Law School. So Israel, Australia, very different countries, but I might note that they're both not in the US, or they're both not the most major countries, but they also both have very unique legal histories. For example, we have a chapter on Jewish legal history, which I hope you wrote, but then we also have the legal history of Oceania, which I think is also fascinating as well. In terms of where they studied, Anat Rosenberg received her Bachelor of Law from the Hebrew University of Jerusalem and her PhD in the direct course at the Tel Aviv University in 2011. I do note there's also seems to be somewhat of a gap between her PhD and her undergraduate degree, which is of course common. I think it's perhaps best for people to take time. I took time before applying and going to law school, but nonetheless, it's important to note, whereas it seems for Arlie Loughnan, she might have gone in a more direct fashion, and she studied her Bachelor of Arts and her Bachelor of Law at the University of Sydney, and her LLM at New York University, and her PhD at the London School of Economics. So the differences here are that Anat Rosenberg has sort of studied in Israel and works in Israel, whereas Arlie Loughnan was a bit more all over the map. She's started in Sydney, but then ultimately ended in Sydney, but she also spent time in both the US and the UK. So the differences in terms of geography there. But in terms of degree, they both have a law degree. They both have a PhD, which makes them more similar than not. But Arlie Loughnan does also do a Master of Law. I'm not saying that was necessary or anything, but it's something to note. And she also does have an additional bachelor's degree, because depending on the jurisdiction, some countries have, like, for example, Canada and the US, you can only do law school after undergrad, unless you're in Quebec, for example. But unless only Quebec. But in other geographies, one can, for example, as we can see with Anat Rosenberg, she went directly into law school, or she doesn't have another bachelor's degree, whereas Arlie Loughnan has both a Bachelor of Arts and an LLB, so which leads me to think Australia is probably the same as Canada in the US, in that law school is per se a graduate program. As well, Anat Rosenberg did postdoctoral studies at the Hebrew University of Jerusalem and the Satcher Institute for Legislative and Comparative Law in 2010, and many other positions. Whereas Arlie Loughnan was a visiting fellowship at Cambridge, University of Melbourne, University College London, Institute of Advanced Legal Studies in 2013, and London School of Economics. So Arlie Loughnan's been sort of a bit over more, but I might note that it's all been sort of within the former Commonwealth, so they've all been sort of Anglophone countries, whereas Anat Rosenberg has been, well, at least in Israel, is probably maybe more, well, many countries in the Commonwealth are multicultural, but Israel is distinctly a mixture of many different peoples, of different backgrounds and such. In terms of publications, Anat Rosenberg has 2 books. However, she's also the editor with Roy Kreitner and the famous Christopher Tolmans. And Roy Kreitner is also great, and we have a chapter and biography on him as well. And Arlie Loughnan also has 3 books. However, she is not the editor, but the writer of all 3. So, but she also co-wrote with them. But they seem to be about similar in the amount. At least they both have 3 books with their names on them. In terms of interests, Anat Rosenberg has History of Consumer Capitalism in Late Modernity, Liberal Thought in Late Modernity, Liberalism Critique, particularly the role of class and gender in liberalism, Cultural Legal History, the interrelations of law and literature, Contract Law, Advertising Law, Marriage Promises, the Victorian and Fin de siècle novel in England. And Arlie Loughnan has sort of lists them in sort of broader groups as criminal law and theory, mental incapacity, and legal history. So one thing in common, legal history. But I think they both had sort of a focus on maybe late England, more recent times, so maybe 1600 to 19th century sort of focus, at least for their chapters. So similarity there, but legal history is, firstly, these 2 are more similar than they are different, because there are many other lawyers and many who don't have PhDs. There are many other PhDs who aren't lawyers, and even amongst those lawyers with PhDs, many of them aren't interested in legal history as well. So they're very, very similar in that regards. However, their areas of research are very much quite different. At least in this chapter, contract law and criminal law are 2 completely different areas of law. Some scholars are experts in one and know nothing about the other. Some people are fortunate to know about both, but that is a clear difference. Whereas also Anat Rosenberg has a lot of sort of maybe down the critical legal studies. She doesn't explicitly note critical legal studies, but she does mention a lot of gender and liberalism, cultural legal history, marriage promises, and also literature as well. So sort of nuance in that sense. Whereas Arlie Loughnan sort of really, maybe through focusing on criminal law, digs into things such as mental capacity and sort of theory as well. So nonetheless, but I think both of them, at least the way I focused on these 2 chapters, they very much seem to have visual minds, in that they sort of said that they see many trajectories, crisscrossing paths, and connect them all. So once again, thank you so much, Anat Rosenberg and Arlie Loughnan, for these 2 excellent chapters and beautifully written and fascinating topics in the Oxford Handbook of Legal History. My name is Kaylin Ashcroft. This is a series on Guide to Legal History and Historians, and I hope you continue to support. Thank you so much.